whether this group doctrine can exist in Indian jurisprudence independent of any statutory provision. That's the first issue as formulated. At best or at worst, the issue can be, which I don't think arises really, but can be theoretically, is a group doctrine created by judge-made law barred by the 96 Act?
Exactly.
Well, this judge-made law exists every day. So many things your Lordship says becomes the law, under 141 or 142 especially. Therefore, Malas, it doesn't have to be found in a statute. Indian law is statutory, Indian law is common law, Indian law is a lordship law, Indian law is customary law. So many sources of law. Now, let's very briefly, I will go under 2 or 3 broad heads. The first is, Malas, I'm very briefly going, the Lordship will pardon us because I don't think we are prepared to the level of a constitutional bench. I said so in the morning. Lordship will put that caveat in front, but we'll try our best. I think most of us were taken by surprise, except Mr. Advani, because we have been a little underprepared. But that doesn't matter because fools do walk in where angels fear to tread. So perhaps I'm doing that for a constitutional bench. I should be better prepared. But Malas, the first head of my submissions is that this reference may not be necessary at all. And a constitutional bench, your Lordship knows, can answer the reference saying no reference arises.
It's deja vu.
No, it might save a Lordship's time.
Collection.
It might save a Lordship's time. Now, Malas, the second set of my submission is going to be an attempt to cull out some 10, 12 or 15 principles of why the group doctrine. This is, Malas, after the first point. Your Lordship need not answer the reference at all. In the event your Lordship answers it, your Lordship should, Malas, comprehensively reiterate and reinforce the group doctrine for about 15, 16 juristic principles. I'll give your Lordship those principles as the second head of my submissions. And the third head of my submissions is to take your Lordships quickly through those relevant paras of the 10, 12 judgments, of which Mr. Advani has only cited 3, which bear out those principles. That's far as the broad 3.
The third aspect of the
Third is for us to take your Lordship through the actual paragraphs. Only some very, very few paragraphs pinpointing from which those principles can be legitimately said to have a juristic basis, of which I will not repeat. Mr. Advani has dealt with those 2 or 3.
Dr. Singhvi, would also like you to, at the end also, maybe in the night, focus on those contradictions which Justice Suryakant has noticed in the judgment.
Yes.
Because assuming that we are with you,
yes,
how do you iron out those contradictions?
Yes.
Because Justice Suryakant in his concurring judgment says uphold the doctrine.
Yes.
But a few of those contours, etc., just give them proper shape. That's the other thing.
Yes.
If I may add a 4th one.
Yes.
That will be the last submission, that it will only be a prima facie view of a referring court.
In a section 11 situation.
And that the arbitral tribunal will thereafter take a decision whether it should be a party or not.
Yes.
Just view on that.
Likewise, Mr. Rai, when you argue, of course, you'll be arguing that there is no group of companies doctrine. We will not stop you from arguing that. But in the manner that you always fairly assist the court, you may also argue on a demurrer that even if you apply the group of companies,
what are its contours?
Then how would your contours? So we'd like you to assist us there.
Yes.
Especially because, they are in one side.
Yes.
So we'd like you to.
No, my submissions would be both.
Excellent. Thank you.
Where the group company may find a place in Indian law, and if it does, what are its contours?
Absolutely. That's
got
it. Yes, Doctor.
We have also hard sets made in the course of day today, but most of it will be Lordship soft copy. If it's not there, then we'll hand a hard set for some cases. Most of it, I think, is with the Lordship soft copy. Now, let's first on the first head. Well, I say with respect that both the learned judges who have formulated, A, have formulated what might be called grounds.
Both the learned judges
have really given, in particular Justice Suryakant, has given grounds, not really issues. I'll just make it good, Let me give you a point first.
Right.
2, Two, minutes, the issue cannot be, as Justice Suryakant with great respect has formulated, for example, whether this group doctrine can exist in Indian jurisprudence independent of any statutory provision. That's the first issue as formulated. At best or at worst, the issue can be, which I don't think arises really, but can be theoretically, is a group doctrine created by judge-made law barred by the 96 Act?
Exactly.
Well, this judge-made law exists every day. So many things your Lordship says becomes the law, under 141 or 142 especially. Therefore, Malas, it doesn't have to be found in a statute. Indian law is statutory, Indian law is common law, Indian law is a Lordship law, Indian law is customary law. So many sources of law. But yes, if the issue is taken to the extreme extent of saying that there is a bar in some sense of the 96 Act, then a Lordship will look at it and see if there is a bar. Or, Malas, the other issue could be that your Lordship says Indian judgments, which are not yet a constitution bench, have wrongly brought in the group doctrine. Per se, it is wrong. That's a policy decision, if I may say so, a judicial policy decision of your Lordships. It should not be there. It's a wrong adumbration, it's a wrong importation. Beyond this, Malas, I don't think the Constitution bench has any other issue to decide. Beholds these two questions. These two questions have not been formulated the way I have put it to your Lordships. They have not been formulated. Now, because the rest is ground, just turn to Malas, para 104, page 41 of Cox and Kings, Justice Suryakant's concluding paragraph. Para 104, page 41 of the SCC, whichever compilation Lordship is using.
Reference order.
No, Justice Suryakant's, yes, the judgment, which is in Cox and Kings, which my lord had read in full.
We are reading from the court's order.
Yes. No, the conclusion, Malas, para 104 is the conclusion of my lord's judgment.
Page 903.
Oh, my lord is using unreported.
903.
48.
Oh, I'm sorry. That might be compilation page, para 48 page.
This is the fourth judge.
That will be page 66.
Para 48. Whichever way, Lord, I was using the SCC. Now, the first issue at 104.1, or rather A issue, issue A, capital A. Does my lord have it? My lord has got it. Justice Roy has got it.
Page 928, page 928.
Justice Pardiwala. Whether the Group of Companies Doctrine should be read into Section 8 of the Act, or whether it can exist in Indian jurisprudence independent of any statutory provision. Because it already existed before. It is existing. The Law Commission tried to clarify it. Suppose, Malas, there was no amendment to it. The only question then would be that is your Lordship wrong in adumbrating a group doctrine, or should it be there in Indian corporate law, arbitration law? Theoretically, this issue is really not arising and would not arise in a situation. I'm assuming that it is not amended. Your Lordship makes declaratory amendments, codificatory amendments in the legislature. Second issue is whether the Group of Companies Doctrine should continue to be invoked on the basis of a principle of single economic reality. That's what is actually a ground. If the Group of Companies Doctrine can have many juristic bases, I'm going to give your Lordship 15 odd bases for that. One of those bases is single economic reality. Now, is there a juristic basis correct or not? Of course, a Lordship can opine on it. But it is clearly there in a lot of case law. Third is whether Group of Companies Doctrine should be construed as a means of interpreting the implied consent or intent to arbitrate between the parties. That's either a ground or a conclusion. The Lordship really cannot decide it in this form. Actually, both fellows implied consent or intent to arbitrate.
Reformulate.
Yes.
We'll put it to you that this is how it could be reformulated.
Yes.
In the Arbitration Act,
Yes.
reading section 7 with 2H,
Yes.
is it not the intendment of the Parliament that only parties who are signatories to the agreement will alone be entitled to? It does not enable, by implication, bringing a party who is not a part of the contract.
I'm grateful. That's really, Manus, your Lordship is making it narrow. I'll make it wider against me. It's not what I said in the beginning. Does the 96 Act
Exclude.
not permit the declaration of a group entity doctrine? Whatever, whether 2H does not or 7 does not, does Manus the Act inhibit?
No, no,
That can only be a bar.
Statute's own expression.
Yes.
Does it permit anybody other than a party to the contract?
Very well. That's the positive way of putting it or negative, either.
When I was typing, I took down your first submission as.
Yes. It's
Where
the same
you
thing.
said, when you said both the learned judges have furnished grounds and not issues. The
Yes.
first point which I took down was, is the group of companies doctrine concept which is created by judge-made law barred by the 1990s?
Barred. Now you can make different words. Don't use barred.
The other is saying barred specifically by
Permitted.
218H
Permitted.
section 6.
But the only thing with permitted is one. Suppose it is not explicitly permitted. Suppose, I'm not saying.
It may not be barred according.
Exactly. It will not prevent your Lordship from enumerating it. Your Lordship does it every day.
But it's not, no, you know, that's not the.
Does not contemplate. Your Lordship uses more to
It
contemplate.
is not explicitly permitted. But could we be reading, would section 7 be read so as to exclude anything but a written agreement?
So does the 96 Act not contemplate that a person who is not a signatory can be
Simple.
That's a better way.
That's right.
No problem.
That's the point.
No problem about this. Does the 96 Act contemplate a person not a signatory to be part of an arbitration process? I'll formulate it more clearly with this for tomorrow, but that's barred maybe too extreme, permitted maybe affirmative. Or should we take a middle view?
This we put it to him so that you can reflect on it in the context that agreement can be implied under the general law of contract and arbitration. Number 2, arbitration is specifically a matter of contract between the parties.
Implied consent
It's not
is
a public law. It's not a public.
implied consent is one of the basis, juristic basis of the
Let's see,
15
I'm
basis.
just putting it to you.
Yes. So, Malas, that would be one issue. The other would be a larger issue I'm putting against myself, that does your Lordship as a constitution bench think it fit that there should at all be a concept in Indian law called group of doctrine? I mean, group of companies doctrine. Namely, that all the judgments are wrong, which have adumbrated it. The judgment should not have adumbrated it. I mean, it's the same thing overlapping, but it's a larger issue. That judicial policy of your Lordship does not contemplate because it's highly unjust, it's highly oppressive, it's unnecessary, it is productive of mischief. Whatever your Lordship is, that's your Lordship judicial policy. That's really only the issues arising according to me. You can put it in different ways, Manus. These are, now see number 4, Manus, D. It's one of the grounds, Manus. They're all bases. Piercing the veil, alter ego. These are all bases, Manus.
Singhvi, what we'll do is, we'll rise right now.
Yes.
That you have a little time to reflect.
Yes.
You know always how you formulate, you know. Sometimes your number 7 is our number 8 or point number 6 is our number 5.
When I oralize it, Manus. When I write it down,
I know that's right. It's on a lighter vein, Dr. Singhvi. So we'll give you, so then tomorrow morning you will have, you'll have the whole evening to reflect and then.
Lordship.
And then Mr. Solicitor will type it too. So it's a very important central act. This will have a bearing on the very course of Indian arbitration.
Lord, I have
So we are happy that you are intervening because you, as the Parliament having.
after my Lord's decision.
No, we were suggesting that why is it that the Law Commission's recommendation was not followed. Just check it out.
To H.
Just check that
But
out.
I have already requested the law secretary that you give me entire details,
Right.
whether it was considered, whether it was a conscious decision not
Or
to.
just a casus omnis.